Good afternoon, everybody. I am Kiki Dilly. I am one of the shareholders here with Altitude Community Law, and thank you for joining us today for Collections Pitfalls. This is a topic that is coming up a lot lately, so I'm glad that we have so many people here to listen and learn and ask questions and hopefully avoid some of these pitfalls moving forward. On your screen, you should primarily be seeing the PowerPoint presentation, and you should additionally be seeing a small box on the left-hand side of the screen with the presenter. That's me. On the right side of the menu, you'll see a private chat icon, and please use that icon to type in any questions that you have throughout the presentation. Questions will be answered at the end of the webinar, time permitting. I'll also try to grab a few questions as I see them, if they're relevant to what we're talking about right then. But like I said, it's time permitting. We want to make sure that we are getting through the full webinar so that everybody can get the benefit of seeing the full webinar. If you have any audio or video issues during the presentation, please click the No Audio or Video button below the PowerPoint on your screen and follow the instructions there. One CMCA credit certificate will be automatically generated and emailed to you within 48 hours after the webinar, assuming you attended the entire program. These credits are not transferable. Please save the image of the certificate that is in the body of the email if you wish to preserve the image. To save the certificate, right-click on the image in the email and save it as a photo. The image of the certificate in the email will only be available for 30 days, or you can print the email that has the certificate in it. As a reminder, this presentation will be recorded and added to the Altitude YouTube channel within a couple of days. And lastly, there will be a survey that will pop up at the end of the webinar. I truly appreciate any feedback that you can provide. Your thoughts and your opinions assist us with improving our future presentations, so please don't hold back. And I really candidly do read all of that feedback and take that into account with future presentations. So I would appreciate any feedback that you are willing to give. All right, so let's get started. Like I said, I'm Kiki Dilly. I'm one of the attorneys here at Altitude, and I run our debt recovery department. I've been doing collections now for 18 or so years. So this is a topic that I know well and have a lot of experience with. So please feel free to ask your questions, and we will answer those as we are able. All right, so first and foremost, who cares about collections pitfalls? Well, there's several reasons. The Colorado legislators have had a pretty good focus lately, as all of you know, on collections and foreclosures by HOAs in an effort to help protect homeowners and make sure that people are not losing their homes when perhaps they shouldn't be, or it's unfair. And so we want to make sure that we as an industry are doing everything that we can to give the legislators as little ammunition against us as possible, right? We want to be better as an industry and do our part and not do things halfway. We want to make sure that we have everything buttoned up on our end to give us the least amount of exposure as we can to the legislature to find fault with what we're doing. Very similarly, the judicial environment that we're working in right now, which means the courts and the judges, generally speaking, don't have the best perceptions of HOAs or collections in general, for that matter. There is a lot of concern right now about fairness and making sure that people aren't being unfairly treated by their HOAs or by creditors in general, making sure that people aren't losing their money unfairly or that they don't have proper notice. The judges and the courts are generally looking to make sure that everyone is following the rules to the letter of the law and making sure that everything is handled correctly to be able to justify finding against owners and actively taking money out of their bank accounts or foreclosing against them and taking their homes from them. So the remedies are pretty extreme when you look at it from the perspective of the owner. And so the judges want to make sure that all of the proper processes have been followed to make sure that those next steps really are the proper next steps. We want to be able to show up in court and tell the judge, look, we were reasonable. We did everything we were supposed to do. This person is not playing by the rules. They're not holding up their end of the bargain. And so what we are asking for is appropriate. There are, of course, monetary penalties for not following the rules verbatim. First and foremost, if we proceed to a trial and the judge finds that the association did not follow the rules correctly and did not do everything that they were supposed to do, the judge can find against the association, which means the owner may or may not have to pay the assessments, probably not if the judge is finding against the association. The judge can find that because the association didn't follow the rules it was supposed to follow, not only does the homeowner not have to reimburse the association for the attorney fees that they incurred in that action, but the judge can also require the association to pay the other attorney's fees, so the homeowner's attorney's fees. So small mistakes can add up to expensive mistakes that can really financially impact associations. There's also a $25 or $25 would be different, $25,000 penalty that can be levied against associations if there are errors in their process and they are foreclosing against someone. So we absolutely need to make sure that everything is done perfectly on those foreclosure matters to avoid that sort of financial impact to the association. So overall, what we're saying is that close enough is no longer good enough. We do need to make sure that all letters are right, all contact with owners are correct, that all the steps have been followed to make sure that we put our associations and our joint clients in the best possible positions moving forward to try to make sure that we can collect as much money as we can from these owners. And also, associations still need money to function, right? So we can't just say there's too many rules and there's too much, red tape and there's too much nitpicking of our letters and our processes and what have you. So just forget it. We're not going to bother with collections anymore. The problem is that the associations need the money. So we really all do have to work together to try to put all of our associations in the best possible financial position and the best position to be successful if we go to court. All right, so we're going to talk about last year's legislation, which is still, rearing its head whenever we are looking at collections moving forward. We are going to talk about the dangers of selective enforcement and how that can pop up in a non-intentional way. A lot of times that'll pop up in ways that, nobody's trying to selectively enforce, generally speaking, but we want to make sure that that's not an issue because that can be a pitfall. Another huge pitfall is bankruptcy violations. And then the distinction between the lien against the property versus the personal liability of the owner and how we can better understand those to make sure that we are getting as much money as we can when we're talking about owner bankruptcies and foreclosures and how those impact the lien versus the personal liability and making sure that we are collecting as much money as we can within those frameworks. Okay, so in 2025, last year, the legislation changed yet again with what is required for the information and the process that is required by the management company or self-managed boards before you send somebody to collections. And this is it's the same deal regardless of whether you use an attorney for collections or if the association uses a collection agency. They are all subject to this same pre-turnover requirements. Everybody is equally frustrated and fed up with the constant changes in the laws, although it looks so far like we're not going to have any additional collection policy revisions with the 2026 legislation. So hang tight, but hopefully this year will give us a break from yet another collection policy amendment requirement. So the last one that we got affected by was the 2025 one. It was effective in October of 2025, and we'll quickly go over what changes the boards need to understand so that you can help your boards understand what changed from their perspective, and then also what you guys need to do, because like I said, we are seeing a ton of judicial nitpicking about whether or not the letter of the law has been followed precisely. So the board, they need to understand that if they have not done so yet, they do need to authorize an update to their collection policy. We can't take any collection action without that. And we also have had judicial feedback recently that said that if you do not have a collection policy that is compliant with the law for any period of time that you did not have a compliant policy, you should not also be charging late fees and interest during that time. So if you have any boards that still have not updated their policy and they're still working off of last year's policy or the one from 2024, they shouldn't be charging any late fees and interest until they get that policy updated. Also can't take any collection action with that. Doesn't matter if it's an attorney or a collection agency. We can't be doing any collection action without that updated policy in place. So the board also needs to understand those new requirements and limitations that went into effect last year. I'm not going to cover these super closely because we have covered that in webinars and articles and whatnot. So feel free to reach out to me if after this you have additional questions about those 2025 changes. But I wanted to just hit on a few highlights that you can share with your boards. They need to understand that the payment plan that the owner enters into with the management company before they ever get sent into collections, if they agree to that payment plan, that payment plan is in place until the owner is either 15 days late with a payment or they have failed to make payments 3 times over the course of that payment plan. It does not have to be 3 times in a row, and it doesn't matter if they missed a payment twice and they were 20 days late once. That counts, that's fine. But we just have to have 3 missed or late payments over the course of that payment plan before we can consider them defaulted out. We can't say you missed the first payment, so you're out. They have to do that 3 times. The boards need to understand that under the law, a foreclosure is a separate legal action from collections. And so if you've had somebody in collections for a year or 2 or 3, and they're now looking at sending someone into foreclosure rather than pursuing collections against the owner through things like garnishments, if that hasn't been successful for whatever reason, because the law considers the foreclosure a separate action, and the law has changed in the meantime, since that person was originally sent to us for collections or to whoever for collections, that in order to proceed with a foreclosure, they will need to restart their delinquency notices under the 2025 collection policy and let all of those timelines pass before you can start a foreclosure against the owner. And I share everybody's frustrations that feels like going backwards and it's a waste of time. And, we've already offered a payment plan to the owner way back when, and they didn't take it, or they did and they defaulted. Why do we have to do it again? Well, it's because of all of the reasons that we said 10 minutes ago, that there are high potential risks to the association by not stopping and restarting those collection notices back again. We just want to, like I said before, everybody wants to put our combined clients in the best possible position moving forward. So while it is very irritating and annoying to waste another, 60 or 90 days sending out new notices to people, it does put them in a better position moving forward to be able to successfully collect in the end. So from the management company side, if they have not already done so, please make sure that collection policies get updated, that they actually get signed by the board, and then it's always best to send that policy back to the association's collection attorney once it's been signed, regardless of whether or not you have collections with them already. It's just another delay and another hurdle that we have to jump through, or another thing that we have to come back and ask for if the policy was signed 6 months ago, but it never got sent back to us. We need to do our due diligence and make sure that the board actually does have an updated current collection policy that has been adopted. So if we get a file asking to open a new collection matter on an association that even if we sent out an updated policy last year, if we didn't get it back signed, we're going to pause and make sure that we get that signed policy back before we start with collections. So it's always best just to send all the signed policies back to the attorney so they can file them away and be ready to hit the ground running if we get to that point with anybody in the future. Make sure that you have changed your internal procedures. Posting is no longer required. Thank goodness. That was kind of a difficult situation for everybody involved. But you do want to make sure that you are calling, emailing, or texting. You're required to do 2 of the 3 of those, the call, email, and text. We no longer are required to send payment plan offer letters via regular mail, but you certainly can still do that. And that can be substituted for the call, email, text requirement if you don't have the phone or email information for the owner. But you can't substitute regular mail for the call, email, text if you do have the ability to communicate with them that way. So if someone has provided you with their phone number, you would need to call and text them to satisfy the 2 out of 3 requirement. You can't say, as a management company, we don't want to bother with that and we just want to send it regular mail to substitute. That's not going to work. The regular mail only substitutes if you are unable to comply with the call, email, text 2 out of 3 requirement. In addition to that, we all know we still have to send the payment plan offer letter via certified mail in addition to the call, email, text requirement. So make sure that your internal processes are working properly. Again, if you have questions about that or aren't sure what those requirements are, we're not really going into that in a lot of detail today. Feel free to reach out to me later and ask. Okay. One of the changes with the 2025 legislation was that if a homeowner requests they get a ledger, the ledger has to be provided to them within 7 business days after you receive that request. I don't know why it is 7 business days and not 7 just regular days, or if it's 5 business. I don't know. I don't know what the logic was of 7 business days, but make sure that you have a system in place that once that email comes in, to make sure that there is a process in place in your office to get a ledger back out to them within 7 business days. Otherwise, there will be the potential for violation there. You also need to make sure that you are periodically requesting phone and email information from the owners and their designated contact if they have provided designated contact information. The law does say that the association is required to periodically request that. We don't know what periodically means, but generally speaking, we've recommended once a year or so. So I know we have associations that with their annual meeting notices, they will also send out, just a little form for owners to fill out that says, hey, please give us your email and your phone if you haven't already. That would, meet that requirement. So make sure that you're doing your job on your end that way to periodically ask for the information. And we also want to make sure that we are documenting everything. You want to make sure in your system that you have a way to document actual communication back and forth with owners, whether that's email, phone, text, physical letters, if you get those from anybody anymore. Make sure that those can be saved in your system. And then also you want to make sure that you are documenting attempted communication with people. So if someone from your office has tried to call an owner to satisfy that call, email, text requirement, you want to make sure that you have documentation of when exactly that call was made, what number it was made to, what happened, if they answered, if they didn't. You want to make sure that even though they didn't answer, you have in your system somewhere saying, yeah, on 5/13/2026 at 12:19, I tried to call the owner at this number. I got their voicemail. And then remember to be flexible. 18 years in, the law has changed so many times, I can't even tell you. So we all just have to, be ready to roll with it the next time the laws change. But we do need to make sure that we keep updated and keep compliant with each individual change. Okay, so quickly, some of the highlights from the collection policy requirement changes from 2025. Again, I'm going to go through this quickly. The policy needs to say when assessments are due and when they are delinquent. It needs to say how much late fees are, what percent interest is, and associations are capped at 8%. So that shouldn't say anything higher than 8%, although some declarations do say a lower amount. We do see some 6% here and there. And return check fees, which are also limited to $20. Policy needs to say that payment plans will be offered to owners, and the payment plans have to be for at least 18 months long. Policy has to say how payments are applied, and that is laid out by Colorado law, how those payments have to be applied. It's first to unpaid assessments and then sort of to everything else. So make sure that your internal accounting systems are complying with that, because that is a change from how things used to be back in the day. And your policy also needs to say that notices have to be sent to the owners and any third party that they request, and we have to send the notices in any language that they request. Your delinquency notices, and by that I mean, generally speaking, your payment plan offer letter. We call that a payment plan offer letter. Every management company calls it something different. So just make sure that when I'm talking about, the delinquency notice or the payment plan offer letter, I'm talking about that one that offers the payment plan that has all the information that is required by statute. You have to tell people the total due and an accounting of that amount. It can be either a breakdown of, overall, here's your total number of assessments, here's the total late fees, or what we see more often is just a ledger being attached, which is great, but make sure that the ledger that you attach goes back to the last time that the balance was paid in full, to make sure that we are providing that full and complete accounting to the owner. Your letter needs to also include whether the balance is comprised of assessments, violation fines, and the associated costs and fees with that, or if it is a combination of assessments and fines. The statute is very clear that it says the letter has to tell people, is the balance comprised of assessments? Is it comprised of violation fines and associated fees with that? Or is it comprised of both? We can't say your balance may be comprised of assessments or violation fines or both. We have to tell them exactly which one it is. And we also have to tell them if your balance includes unpaid assessments, that may lead to a foreclosure against your property. We have to tell them that they have 30 days to either pay the balance or enter it into the payment plan that's been offered. We have to give them the name and the contact information of the person that the owner can contact to verify their debt or enter into a payment plan. Again, the statute says the individual that the owner can contact. So what we don't want to see is a letter that says, accounting at altitude.law, because that's not an individual. That's a generic address. The statute requires a person. The letter needs to offer an 18-month payment plan. The statute lists two different options, so we recommend including, frankly, the statute is poorly written when it comes to the payment plan offer, and it's not entirely clear if these are supposed to be the same offer or two separate offers. So what we have recommended is including both options, and that way you have your bases covered. So one option is an 18-month payment plan with equal monthly payments towards the past due, plus current assessments as due during the payment plan. The other option is 17 monthly payments of $25 towards the past due balance, plus assessments as due during the payment plan, with the balloon payment of anything that is left over on that 18-month. We also have to have delinquency cure language about how they can pay the balance due and what may happen to them if they don't. Lists all sorts of information about, all of you may have a lawsuit filed against you, you may have a garnishment, you may have foreclosure, et cetera, et cetera. We have to have covenant enforcement language in there, even if their balance does not comprise of any covenant violation fines. The statute doesn't say anything about you only have to have this language there if there are unpaid covenant violation fines. So we say just add it in there for everybody. We have to have language about how small claims court is available to either party, as in to the association or to the homeowner, to pursue claims against the other one. We see a lot of letters that come through that say the association has the right to sue you in small claims or county court or district court, but the statute specifically says that it is available to either party. So we need to make sure that the letters say you or the association can pursue claims in small claims or, wherever against the other party. There's information that needs to be in there about publicly available information to owners through the HOA Info Center and then also through HUD. So we need to make sure that that information is in their letter. And we have to tell them that if they request a ledger, we have 7 business days to provide it to them. All of that needs to be included in your letter. That letter needs to be sent by certified mail and 2 of the 3 email, phone, text, as I said, or by regular mail if you are unable to email, phone, or text them. The regular mail can substitute for any of those 2 of the 3 if you don't have the information for the owners. You have to send it to an email or a number that the owner has provided to the association, so you don't have to go out and get a skip trace against them to try to find an email or a phone number. If they haven't given you the information, you can satisfy the requirement by regular mail. And posting in regular mail are no longer required, although you can do those if you think they are helpful or the particular collection policy provides for them. When you refer a delinquent account to either an attorney or a collection agency, the board has to enter into executive session at a board meeting and vote on sending the account to collections. This cannot be done by email because the board has to be in a meeting and then go into executive session. And that needs to be documented with either a signed resolution or meeting minutes saying that the board voted to send this particular owner of this property into collections. If you're doing the vote recording in a resolution, you can say John Smith at 123 Main Street. That's fine. But if you are recording the vote in meeting minutes, you don't want to say the board voted to send John Smith at 123 Main Street into collections. It's always better to use an account number or something like that that doesn't specifically identify the individual that is being sent to collections. Okay, moving on to selective enforcement. And how do we see this come up? Usually it is not board members saying, I like this person, don't send them to collections. I don't like this person because they're the wrong color or they have the wrong religion or something like that, so send them to collections. It is not generally that overt or intentional. But I will tell you, so many of the people that communicate with me about their balances will at some point in their communications with our office say, so-and-so also has weeds in their yard and they're not getting fined from their HOA. Why am I getting fined when they're not? Or I'm pretty sure that, Joe Schmo down the road also owes a balance because he doesn't pay any of his bills and he brags about it to everybody. And I don't understand why you're going after me and not him. People say that sort of thing all the time because generally speaking, people aren't telling their neighbors that they're in collections. Nobody actually wants to admit that to their neighbors. And so even if their neighbors are in collections or they are being enforced against, a lot of times people don't know that and they assume that it's about them personally. So it's something that comes up a lot and we need to make sure that we're putting our boards in the best possible position to not be subject to a selective enforcement claim because it comes up all the time. We see it come up a lot because the board doesn't want to send somebody to collections because they know them and they feel bad for them. It's not usually, I like this person and so I know I'm doing something underhanded by shifting the rules for them a little bit and not sending them to collections. It's usually because they know the person and they know their financial situation and they know they're going through a hard divorce and they know money is rough, or they know they just got laid off and so money is tight. Or they know that they're elderly and maybe they're on a fixed income and they just don't have the money to pay. It is great that the boards are coming at their positions from a place of empathy, but it is not the right decision in order to put the association in the best financial position that they can, because these board members do have fiduciary duties to the association to collect when people aren't paying. So they can't make that decision to send somebody to collections because they don't know them, or because they don't like them, but then not send somebody who owes a similar balance to collections because we feel badly for them. It's a little bit harsh and counterintuitive, but that's the reality of the situation. We also see selective enforcement issues come up if we have boards who are agreeing to different settlement situations with people in similar situations. So what I have here is, as an example, we want to agree to waive only 50% of this person's late fees and interest because they complain all the time and they're generally a pain in the butt and they come to our meetings and tell us that we're doing a bad job. But and also this person is a different color, or this person's children tend to run amok across the common area and are generally a problem for the association, whereas this person is very quiet and we have no issues with them, and we're going to go ahead and waive all of their late fees and interest to come to a settlement. That will get the association in trouble. So if they have a consistent policy of, if somebody comes to the table and they want to agree to a settlement, we'll waive late fees and interest. It is good to have that kind of a consistent, it doesn't need to be necessarily memorialized in the formal policy, but just across the board, we want to treat everybody the same. Because people say that all the time, right? They're being treated differently, whether they are or not. And we want to make sure that there is not even the hint of an unintentional selective enforcement. Okay, moving on to bankruptcy violations. When an owner files a bankruptcy, an automatic stay goes into effect immediately. And that automatic stay prevents all of their creditors from doing anything that looks like trying to collect a debt from them. There's generally two different bankruptcies that we see owners file. If you have someone who is unemployed or severely underemployed and is just not able to pay for their life right now, a lot of times those people will file a Chapter 7. And a Chapter 7 is generally going to be a liquidation. Sometimes they're getting rid of cars and homes, but they just generally don't have enough money to pay all of their bills. Those people file a Chapter 7 usually. And in a Chapter 7, the automatic stay covers only the person who filed the bankruptcy. So if my brother and I own a property together, if I file a Chapter 7 bankruptcy, if we are not paying our dues to the association, you can still take my brother to collections and collect our balance from him if I have filed a Chapter 7. Now, Chapter 13 is different. A Chapter 13, we generally see people file those who have steady income. They just need a break from collections to be able to repay their secured creditors. And the association counts as a secured creditor because we have a lien against the property. So they usually just need a break to be able to repay their secured creditors and get rid of all of their unsecured debt. So things like medical debt, credit card debt, things like that fall under the unsecured debt category. And they're usually wiping out, or very nearly wiping out, paying pennies on the dollar to their unsecured debt, but repaying in full their secured debt if they want to keep that that property. So if they want to keep their car, they want to keep their house, they're going to repay their creditors for the car, for the house, all of that, but they need a break from all the collections. And so those people are going to file a Chapter 13, which drags out for seemingly forever. They usually take 3, 4, 5+ years to go all the way through. But if they successfully complete their Chapter 13, you will eventually get repaid everything that you were due before the bankruptcy, and they're supposed to pay their current assessments during the bankruptcy. It just takes a long time. But in the Chapter 13, the automatic stay covers anybody who filed the bankruptcy and any co-debtors. So back to my brother and I owning property, if I file a Chapter 13 and he does not, you still can't send him to collections. Even though he didn't file the bankruptcy, my Chapter 13 covers him. Again, any questions on specific matters that come up like this, I always encourage people to reach out to the association's collections attorney, because I would rather answer the question and make sure that we don't have problems down the road. So what does that look like from you guys? If you record liens on behalf of your associations, you do not want to record a lien against anybody who has, or against any property whose owner has filed a bankruptcy. The lien, yes, is recorded against the property. It's not about the owners individually, but really, why are you recording the lien? You're recording the lien because you want to collect money that's due on that property. So that can be considered violating the automatic stay. Don't record the lien if you know somebody is in bankruptcy. What else does that look like for you guys? You want to make sure that if you receive any sort of bankruptcy documents from the bankruptcy court or from a bankruptcy attorney, from the owner directly, an owner shows up at a board meeting and mentions that they filed bankruptcy or says that they're about to file bankruptcy, excuse me, or you're passing somebody at the mailbox kiosk or walking their dog and they happen to mention to you that they're filing bankruptcy, please let the association's collection attorney know right away. We do periodic checks, and most collection attorneys do the same thing to make sure that people haven't filed bankruptcy that we don't know about. But if you guys know, we are considered having known, and vice versa. So we need to share the information with each other to make sure that we're not accidentally violating the automatic stay by sending out notices to people or defaulting them on a payment plan that they have with us, or requesting judgment against them if we're going to court. Whatever information you get, please share that information with your association's collection attorney right away. Now, another item for management companies to know, I'm sure you all know that one of the requirements is that, or one of the legal requirements that changed within the last couple of years, is that you are required to send monthly invoices to any owner that has an unpaid balance due. That's required under Colorado law. Bankruptcy is federal law, which is a higher priority than Colorado law, and says don't violate the automatic stay. So the way that we recommend meshing those two requirements together, if you have somebody who is in bankruptcy, we recommend that you continue to send monthly invoices to the owners while they are in bankruptcy. However, there is language that we recommend you add to your monthly invoices that say, if you are in an active bankruptcy, this is not an attempt to collect a debt. It is for informational purposes only. And that way you can satisfy both requirements of sending out those monthly invoice statements that you're supposed to, but also not violating the automatic stay. For anyone who doesn't have that information, my email is going to be at the end of the presentation. Shoot me an email and just ask for that. The bankruptcy information or language to be put on monthly invoices, and I will send that over to you. We don't charge anything for that or anything. It takes me 12 seconds. So I'm happy to share that with you to keep all of us from getting in trouble with bankruptcy. And remember, homeowners' bankruptcy attorneys are extremely aggressive about prosecuting violations of the automatic stay. We several years ago, we had a bankruptcy attorney who claimed a $10,000 violation, or requested $10,000 from us because of one letter that went out to his client just a few days after she had filed bankruptcy. The notices had literally crossed in the mail. They did not get $10,000, but I tell people that anecdote just to really drive home the bankruptcy attorneys are all over automatic stay violations. And so we just need to make sure that everybody stays in the loop as soon as an owner files bankruptcy, and we make sure that we are not giving them the opportunity to try to get $10,000 for, violating the stay. Okay, and then take a water break here real quick. And then the last topic about collection pitfalls that I wanted to bring up was understanding, or really the pitfall, I guess, is not understanding the difference between the balance that is due on the lien against the property versus the balance that is due on the personal liability of the owner. So if we think about the balance that is due to an association on a certain property, there are kind of two different tracks that associations can take to try to collect that balance. You can't double collect, but you do have these two distinct liabilities that we can go after to try to collect the balance in total. On one hand, we have the lien that is against the property. It has nothing to do with who happens to be the owner at that time. The lien is just about the balance that is unpaid against that property. It is usually not going to be impacted by a particular owner's bankruptcy unless, and it is very infrequent, but unless the bankruptcy court specifically says the lien against the property for this association is gone. That is very rare, and we're pretty successful, or very successful at arguing against that happening. So generally speaking, the owner's individual bankruptcy is not going to impact the lien against the property. The lien is impacted by the owner's mortgage company foreclosing on the property. So we'll talk about specific circumstances down the road here where it pays to understand the difference there. If you have an owner who has gone through a bankruptcy but not a foreclosure and then tries to sell the property. So we have the balance due on the lien. And the balance due on the lien can be a different amount than the balance that is due from the owner and their personal liability. So the personal liability of the owner is about the balance that is due from that particular owner because they were the owner of the property. And, Kiowa says, your documents say any individual owner is responsible personally for paying the assessments that came due against that property while they were the owner of the property. And generally, when you send people to collections, we are collecting on that personal liability. So we are going after the personal assets of that owner. We're suing them personally. We're collecting against them, by garnishments of their wages, garnishments of their bank accounts. That's all about the owner's personal money and the money that they were personally responsible for paying to the association. That personal liability is what the owner files bankruptcy to get rid of. The personal liability is wiped out if that owner files bankruptcy and goes all the way through their bankruptcy and receives a discharge from the bankruptcy court. We are no longer able to personally go after that owner and sue them individually for that balance due. But that owner's personal liability is not impacted when their mortgage company forecloses on them because that's just about the lien against the property. So what does that all mean for you all? If you have an owner who has gone through a bankruptcy but has not had their mortgage company foreclose against them, we can no longer sue them personally to try to collect the balance that was due from them because they wiped out their personal liability in their bankruptcy. But that doesn't impact the lien against the property. So if you have somebody who went through bankruptcy, you can't collect them against them anymore, but that lien is still valid out there for the pre-bankruptcy balance. So if you have this owner who has kept their property through the bankruptcy, and now they're trying to refinance or sell to a new owner, we want to make sure that we are collecting that pre-bankruptcy balance as well, because the closing or the refinance is about the lien against the property. It doesn't have anything to do with the owner's personal liability. So you want to make sure that you keep track of that pre-bankruptcy balance in the event of a closing or a refinance, because you can also include that amount in your status letter amounts and get the association that money that we wouldn't otherwise be able to collect personally from the owner. So the flip side of that is if you have someone who their mortgage company has foreclosed on them, the lien is gone by law, other than the super lien, which is the equivalent of 6 months of assessments. But otherwise, the lien on the property is gone. You're not going to be able to collect that balance due from future owners or future sales or foreclose against the property or anything like that, because the mortgage company's foreclosure wiped out the association's lien on the property. But the owner is still personally on the hook for any assessments that came due while they were the owner, regardless of their mortgage company's foreclosure. So you can still proceed with collections, against that owner. We can still garnish that owner because their personal liability is not affected by the mortgage company's foreclosure. I recognize that this is a little bit in the weeds, and I would encourage all of you, if you come up with these circumstances where you have, foreclosure and bankruptcy and closings and, whatever else you have going on, always reach out to the association's attorney to confirm the balances and what is due from whom, so that we make sure that we always are collecting the maximum amount that we can under the law, and not just, assuming that because this person went through bankruptcy, we can't collect in a refinance or a future sale, something like that. We don't want to miss out on collecting that money from the owners when we can. So we have some time for questions, which is good because I have a ton of questions here. So I'm just going to go down to the bottom and start at the beginning. So the first question says, if owners were sent to collections, but the notices and verbiage were not compliant with legislative changes, does the notification process have to start over from the beginning once the notice template is corrected? Yes. So in theory, if you send someone to collections and the notices that the owners received were not compliant with the laws, then they should have been not put in collections at that point. But if you're trying to foreclose against someone now, or in order to get them into collections, then yeah, you would need to restart the delinquency notices under the current compliant collection policy, send them all of the required notices. Once those notices expire, then send them to collections at that point. I have a question that says, I'm assuming that we cannot put language in the original collection notices regarding both regular collection and foreclosure information. You can. The general template that we provide for delinquency notices covers all of the language that would need to be sent to an owner, whether you're trying to collect against them personally or foreclose on the lien. The problem that we run into is that if there is a law change after someone has already been sent to collections, and now we're trying to switch gears and go into foreclosure, if the law changed between that initial letter being sent And when you're trying to move ahead with a foreclosure, that's when the updated letter has to be sent out. It's not that there's one particular letter for collections and one particular letter for foreclosure. It's that the law keeps changing. And if the law isn't changing and you send out a letter, a payment plan offer letter that is compliant to the owners, and we want to switch gears to go to foreclosure, presumably that letter is compliant either way. But each time the law changes, that's where we reach the problem of having to go back and send out new letters, because we just have to send the new updated letters regardless of what we're doing. We just happen to be starting a foreclosure. So as long as the law doesn't change, your letters should be compliant for either foreclosure or collections. It's the law change that causes the issue there. I have a question that says, we have someone other than the homeowner living in a condo. The lease expired 2 years ago. No assessments have been paid by the homeowner for 18 months. How do we get the renter out of the condo unit? The short answer there is that the renter is not really the association's problem. We don't have any ability to interfere with a contract to rent the property between the owner and the tenant. It is the owner's problem or fault that this tenant is still in the property, even though their lease expired a couple of years ago. Now, it is the association's business and problem that the owner has not been paying assessments. It is not the tenant's problem to pay the assessments. It is the owner's problem to pay assessments. Even if the owner and the tenant have some agreement between the two of them that the tenant is supposed to be paying, the law says that the buck stops with the owner. So the association should be sending the owner the delinquency notices. And once they go to collections, that's really valuable information to tell the collection attorney that there's a tenant in the property, because we can ask the court for a receivership, which is a third party that the court will have step into the shoes of the landlord and act as the landlord on the property. So the receiver would come in there and say, hey, tenant, you're not here under a lease. So, provided the tenant's rights, squatters' rights and whatnot are recognized and complied with, the receiver will say, look, tenant, you either need to agree to a new lease or you need to vacate the premises or get evicted, again, following all of the squatters' rights and whatnot. But that is something that they can do. Then the new tenant either starts paying under a current lease, or they get evicted and the receiver puts a new tenant in there that starts paying. But the receivership process allows that rent payment to go from the tenant to the association to repay what the owner should be paying the association for assessments until the association gets paid. And then the receiver steps out and that tenant now becomes the owner's problem again. And maybe our problem down the road when the owner still doesn't pay. But that is a way that the association can use a tenant being in the property to get the owner's unpaid assessments paid, but there's no direct way for the association to engage with a tenant and say, tenant, you don't have a current lease, so you need to take care of that. That's really the owner's problem. Now, there also may be covenant enforcement violations there, but again, all of that is going to go against the owner, not against the tenant. So the interactions between the association need to be association to owner, whether it's about the unpaid assessments or about, they have to provide a copy of the lease or whatever it is that the covenant violation might be. I would encourage you to reach out to whoever the attorney is for that particular circumstance to figure out the best way forward on that situation. But that's generally how we would look at it. I have a question that says, for collections, if we have a phone number, but it is incorrect, can we make a note and send regular mail? Yes, absolutely. You are not required to make sure that the information that the owner has provided to you is current and accurate. You just have an obligation to try to contact them there. You did your part by trying to call them and text them at that number. You internally note, we tried, didn't work. You can certainly send the regular mail as kind of a boots and, or what is it, suspenders and belt situation. But as long as you tried to call the number that they provided you and you tried to text that, that counts as the 2 out of 3. So you can either say we don't need to send by regular mail, or best practices is probably send by regular mail in addition, and you have your bases covered. Does email, text, and sharing being a portal count for a payment offer? Yes and no. If coming to the owner, it looks like a text and it looks like an email, then it doesn't matter how you get that information to the owner, whether you have, email to email, or if it's coming from a portal, that's fine. But what doesn't count is if the only way they know that some information is coming to them is because if they log into the portal and they have a little number 2 notification, that's not going to count. What you need it to do is be received by the owner looking like an email and looking like a text. Like a text to your phone, and they don't know if it came through the portal or not. That would be fine, but we can't have the owners having to take additional steps to see if they are being communicated with beyond, I got a text, I got an email. And now a follow-up question says, so are we now allowed to call regarding collection without being a registered collection agent in Colorado? I would suggest reaching out to the management company's attorney for any questions specific about your processes. But what I can tell you is that Colorado has specifically said that management companies are not considered collection agencies for the purposes of fair debt collection laws in Colorado. And the law does require the association to attempt to reach out to owners via email, phone, and text. And so my suggestion or my recommendation and my understanding of the law is that the management companies, as the association's agent, should be reaching out to the owners, email, phone, text. And I know that is how most work, but I would certainly defer to your management company's attorney for any kind of coverage that you would need, or any fail safes to put into place to make sure that you're not violating any laws. But my understanding of it is that the management company is not considered a debt collector or a collection agency, and so not required to be a collection agency and comply with the collection agency rules. I do, you don't. Can a board vote to only send one member at a time to collections, starting with the highest balance due, and not claim selective enforcement since the others were not? I suppose that's a method you could use. If you're trying to save money on collections or something like that, I can understand that. I think if there is a method to the madness and consistently implemented, I think that's fine. You might have problems on the other side with not upholding their fiduciary duties to collect all unpaid balances. But I think that is a defendable way of handling the situation. Is it appropriate to send the HOA's collection policy along with the delinquency notice that is mailed out, or is that a violation? It's not required, but it's not a violation either. I think either way is fine. Most associations and management companies do not send out a copy of the collection policy with the payment plan offer letter, probably because it just adds more postage. But there's no problem with sending that if you want. I managed an association that had a deal made by the previous management company. They had an email agreement that an overdue account would be paid when the unit sells. It's been on the market for over a year and a half. Can the board turn them over to normal collection since the home is not selling? I think that's very fact specific, and we would need to see the actual discussion between the two, if that was in writing or signed, or if it was just a wink wink and a nod nod at a board meeting. I think the specifics of that circumstance will dictate whether or not you can send them to collections now. If an owner defaults on their payment plan, do you have to let the owner know that the board has made the decision to start the lien process with the attorney? You can, but you don't have to. Most of the payment plan offer letters, as well as the actual payment plan confirmations that I see go out to owners, specifically say that if you default, you're going to be sent to collections. If you told them they would get a notice, you need to send them one. But otherwise, if they've defaulted 3 times, you can send them to collections without some sort of additional notice to them. What if you can't get phone or email from the owner? Does regular mail work as a substitute if you document? Yes. What information is shared with the property manager for the board on the status of a delinquent handover? At my office, we have, obviously I can't speak to other firms, but I can tell you at our office, we have a status report application on our website that is available 24/7 at no charge, that is updated every night with any activity that happened on the account in our office within the prior 24 hours. So that information is available all the time. More also obviously available by phone or email if you have any questions, but as a baseline communication, that is the information that is provided to the management company about pending collections. I have a question that says, what does the content of the phone call need to be? Do we just tell them they will be getting a certified letter? That's a question that I have gotten a lot, and I don't have an easy answer for you. I know some management companies will actually start reading the payment plan offer letter to people until the person tells them to shut up. I think that is the safest option, although certainly probably the most awkward and weird option. I think anywhere that you stray down the continuum from actually reading them the letter to telling them that they need to call, telling them to check their mail, telling them to check their email, the further away you get from reading them the letter, the more open to potential compliance issues you could get. But honestly, I have not seen any judges address that particular issue, so I don't have an easy answer for you there. We typically send a statement and copies of all the unpaid invoices to the delinquent owner with every 30, 60, and 90-day letter we send. Is that actually required? No, you're not required to send them copies of everything. The only information that is statutorily required is you have to send them monthly invoices if they have a balance, and the payment plan offer letter needs to either include a ledger that itemizes the balance or a summary of the balance that due by category, but you're not required to send them copies of everything that you've already previously sent them. We have owners who want to plan for shorter than 18 months. Can the board approve that? Yes. The board can approve a payment plan for less than 18 months if the homeowner asks for it. But the board cannot say, we don't want to offer 18-month payment plans. We only want to offer 12 months. They have to offer at least 18. The owners can agree to something less if the owner wants to agree to that. And I think that, oh, wait, no, one more. You mentioned that Altitude has a template that includes everything that needs to be included in the homeowner delinquency notice, payment plan offer letter. How does one go about obtaining this? If we drafted the updated collection policy for the association, we would have also drafted a template delinquency notice that covers everything. If we, and I can, email me and I'm happy to forward that over. If we did not do the updated collection policy, we can certainly provide a template, but we would charge for it. So reach out to me and let me know if that's something that you need, and I can look it up to see if we have it already done. I'm happy to send it. If not, I can get you pricing on that. So I think that covers all of the questions. Again, my email is right there. Please reach out to me if you need the bankruptcy language for your monthly invoices, or if you have any additional questions or follow up on anything that I've said, or any questions maybe triggered something in your brain. But I will log off here since it is 1:04. We are 4 minutes over, and I will tell everybody to have a great rest of your afternoon. And thanks for joining me. Bye, everybody.